That means 12 months computed according to the British calendar. There is nothing in the Act which makes this meaning of the term year repugnant to the context for delimiting the term of the elected office bearers. This result also flows from the express language of subsection 3 of section 4 of section 28 capital A. Reconciling the two provisions, it becomes obvious that once a managing committee has been elected, its life will be 3 cooperative years only. But within the span of life, the managing committee every year is called upon by such subsection 4 of section 28 capital A to elect the office bearers, including the president among its members. It is, of course, true that while undertaking such yearly exercise for election of the office bearers, from amongst the members of managing committee may find that lost body of the elected office bearers may not get the full span of 12 months. Life as the managing committee's own term may become to an end by the end of the third cooperative year. But that would happen not because subsection 4 of section 28 capital A of the Act, but because of the fact present body itself ceases to exist at the end of the third cooperative year, taking with it office bearers elected from among its own members who have to vacate their office as managing committee members at the end of the third cooperative year. Reliance placed by the learned counsel for the respondent on section 29 capital A of the Act also to avail, as that refers to commencement of the term of the office of the managing committee. That was nothing to do with the term office of the elected office bearer from amongst the members of the managing committee, as laid down by subsection 4 of section 28 capital A. Learned counsel for the respondent number 3 had also placed a strong reliance on section 63, especially subsection 4 capital A thereof. Even this provision is of no avail to the respondent for resolving the present controversy, for the simple reason that audit, inquiry, inspection, surcharge accounts have to be made up for each cooperative year. Therefore, the statement showing the receipt and disbursement to profit and loss of the balance sheet would naturally refer to that cooperative year. The term year as employed in the latter part of subsection 4 capital A section 63 must necessarily take color from the term each cooperative year as employed in the beginning of the subsection. Such is not the case where subsection 4 of section 28 capital A, which covers entirely a different field, independent of the field covered by subsection 3 of section 28 capital A. Reliance placed by section 27 of the Act is also no avail for deciding the present question at all. The mandate is annual general meeting of a cooperative society has to be held once in a year. That year has nothing to do with the term of the office bearers of a cooperative society that ought to be elected as per section 28 capital A4. A faint attempt was also made by the learned counsel for the respondent number 3 to rely upon the bylaws of the society to indicate a different intention. But it is well settled that bylaws cannot cut across the mandatory scope of the section. Hence, this attempt was also futile attempt of recapture. Subsection 4 of section 28 capital A endorsed the members of the managing committee, election among themselves, the officers of the cooperative society every year. It thus implicitly prescribes the term of the earlier elected body or office bearer to be 1 year, while subsection 3 of 28A deals with the term of office of the managing committee itself, which is laid down to be 3 cooperative years. Thus, both these provisions deal with different topics and are enacted for catering to the requirement of a different fact situation. It is true that subsection 4 of section 28 capital A nowhere expressly provide for term of office of the cooperative society, etc. Then, my lord, this is further later. Ultimately, why I am referring to it, your lordships may kindly see, my lord, definition of the year under the Act itself.
Cooperative society and security society.
Section 2, clause F, my lord.
Yes.
The year means the year ending on 31st December, or in case of any society or a class of societies, the accounts of which are made up to any other date which previous sanction registered, year ending with such. This is the definition of the year. Then, my lord, the term of the office bearers are not specified in the Act itself. It is not specified. Term is specified under the bylaw of the society.
Yes.
Your lordship may kindly go to the bylaw for a moment. Bylaw is page 48, annexure K.
48.
48, annexure K. Relevant is page 50. Clause 6 of the bylaw at the bottom, my lord. Page 50, bottom, my lord. Last line of page 50.
50 is the beginning of annexure K.
I think, my lord, some pagination mistakes. Clause 6 may kindly be seen, my lord.
Clause 6.
Yes. 5 is the jurisdiction 6.
The year of the association shall
Yes,
be financial.
year of the association shall be the financial year.
Page 52. Yes.
Then, my lord, term of office is specified under, my lord, page 50,
Clause AD.
58, my lord.
Give us a clause because numbers are not correct.
Yes, clause 12, my lord.
Clause 12. Page 60.
Correct.
Term of the CEC is
The term of the CEC, Central Executive Committee, ZEC, zonal, etc., shall be for a period of 3 years. They will continue to hold the office till now. Committee is elected in their place.
new committees.
My lord, years does not prefixed with the financial year. Therefore, year employed in clause 12 is nothing to do with the year employed under clause 6 of the bylaw of the society. This is precisely the point considered by the full bench dealing with Karnataka Cooperative Societies Act. Therefore, my lord, this term,
When period of 3 years,
3 years, it is a one clause. Then they can continue till hold the election. 2 clauses are there. If for any reason board could not able to continue, then after expiry, even after expiry of the term, the board could not able to continue for various reasons, then appointment of administrator is permissible. Suppose board could able to continue, then later part of the clause 12 of the bylaw would comes into picture.
the later part of clause 12 is contrary to section 27A1B.
Well, at 27A, well, at 20, that's what I wanted to say. Who Societies Registration Act does not specify the term of the office, as in Cooperative Societies Act.
By the act.
By the act. Therefore, act does not indicate what's the term of the office bearers of a governing council of a society.
Yes.
Term is specified under clause 12. Clause 12 consisting 2 components. One is 3 years is a regular period. Remaining period till they elect a new body.
So if the existing committee does not hold election,
That's a different aspect. What I am submitting is, you hear is that situation is not there.
consequence is that.
That's I do agree. I will. Well, what happens in
Yes,
our
premium.
case? In our case, what happens is, previously a notice was issued to us. We indicated that certain things are to be completed. Therefore, we require some more time to conduct the election. Then that request we sent it to the registrar. Later on, my lord, again they sent a letter to us. You have to conduct the election within 7 days, like that. Then we said, no, it's 7 days. It is not possible for these reasons. We have established our own calendar. Election will be conducted on the 5th January 2025. This is the assurance we have given. Now the question would be, the document is also produced. Question would be, my lord, the registrar, while submitting a report, he rejected that request without any reason. That report may not accepted by the government. Now the two things to be analyzed by your lordships in this matter is, what is the scope and jurisdiction of the power of the registrar send a report? What is the later part of decision taking process of the government? These 2 components are there. My first part of the component is, registrar had to submit a report which inclusive of the statement or objections or request, whatever we may, that also to be accompanied in the report. While considering the report, government has to take a decision. This is precisely the reason I won't accept your request. Therefore, I am appointing an administrator. That is not forthcoming in the impugned order. May I kindly see the order for a moment.
Which statute provides for that explanation to be given first, and 2, for it to be considered?
Beg your lordship.
Which statute, which provision
My lord,
provides?
section 27 capital A itself says so.
Does not appear to be so.
Section 27 capital A may kindly be seen, my lord. Can I read it?
Yes, please.
Notwithstanding anything in this act,
Hmm.
where any of society on account of pendency of litigation or otherwise has not held or is unable to hold annual general meeting. May kindly see the language. Otherwise has not held or unable to hold the annual general
That
meeting.
is for the AGM.
Yes, 1 minute. Then, the term of the office of the members of the governing body of a society are expires, and a new governing body has not for any reason been constituted. Third, C, where on a report made by the registrar, on a report consisting of subsection 1, class A, class B.
So their contention is it comes under B, not A or C. See, B does
No,
not
no.
provide for. A
B-
provides for the
My lord,
discretion.
B.
Provides for the discretion.
My lord, A and B cannot be read isolation. It can be read cumulative with class C, A, B, C to be read. Why A, B is necessary is,
Or, Mr. Rajgopal, it's all disjunctive or for all of them. A, so and so, or not holding, or B, not constituting, or report made by a registrar.
correct. A report made by the registrar in related to the contingency covered under class A and B. C does not have any independent enabling provision. C is a running provision in context with class A and B.
That is
C
what we
is not an independent
pointed
provision.
out that official gazette, comma, appoint should be the next line. It
Correct.
can be continuation.
When appointment is, where on a report made by the registrar, I would like to put it in this way, Miro. If the elections are not held, or if he could not be able to hold the election, government cannot directly intervene under section 27 capital A. It requires a report from the registrar. The enabling provision to submit a report to the registrar provided under class C. Without there being a report by the registrar, the contingencies covered either under A or B could not be given effect to.
Is your submission.
It's my submission. I can take support from the judgment of our High Court in that context.
For even A and B, a report is
Yes,
required.
A and B.
If there's a judgment, please give us.
Yes, my lord, your lordships may kindly see. Arvind Kumar judgment ಇದೆ ನೆನ್ನೆ ರಾತ್ರಿ ತೆಗೆದೇನು 2005 KLG. Yes. ತೆಗೆದಿ 2016 2 KLG. ಈ ಕಡೆ ಬನ್ನಿ ಅವ್ರು ತೆಗಿತಾರೆ. You come here. You come that side. 2016 2 KLJ 508 ಇಲ್ಲಿದೆ ತಗೊಳ್ಳಿ ಅವ್ರಿಗೆ ಬಂತು.
Yes.
At paragraph 5, I would like to take below. Third respondent has filed a statement of objection supporting the impugned order, contending inter alia that petitioners have no locus standi to file the writ petitions on account of complaint received against the fourth respondent association. It had committed serious acts or omission. On commission, on enquiry came to be initiated. It was found in enquiry there was been non-compliance of mandatory provision under section 11, 12 and 13 of the Act. As such, there was no need for issuing any notice to the fourth respondent association or to any other person prior to appointment of administrator. Well, this is the gist. It was a justification on the part of the other side. It is contended that subsequent to the enquiry report and the recommendations of the appointing administrator by the communication director so and so, first respondent exercised the power vested under section 27 capital A of the Act as appointed an administrator. Therefore, it is clear class A, B is in consonance with class C To be read together, not isolation. Then paragraph 6 may kindly be seen. Perusal of the records would indicate that petitioner 1 and 2 are the joint secretaries of 4th Respondent Association. Third petitioner is a member of the 4th Respondent Association. He is also Vice President of Cocoa Federation of India, which is the parent body of the 4th Respondent Association. Fifth respondent here is said to have been filed a complaint before so-and-so. Certain irregularities in working at the 4th Respondent Association as per Annexure D. Based on the said complaint, third respondent initiated an inquiry, issued a notice to the 4th Respondent Association. The headquarter assistant office of the district registrar Gandhinagar, Bengaluru, have been appointed as so-and-so. He made into the allegations made by the complainant. Third respondent issued a notice on so-and-so, 4th Respondent Association. During the course of an inquiry, second petitioner has appeared on behalf of the 4th Respondent Association, filed the copies of the balance sheet, statement of audited account, income and expenditure of association, also the list of members of the governing body, as was filed before so-and-so. Wide Annexure F. Inquiry officer on perusal of the record has submitted a report on 21/6/2014, Annexure G. Said inquiry officer who conducted an inquiry into the allegation made in the complaint has arrived at a conclusion that allegation made by the 4th Respondent Association of not having submitted is not proved by the complainant. It is also complainant was fully aware of the audited balance sheet, income and expenditure account of the 4th Respondent Association for the past 15 years. As such held, there was no materials to establish that there has been any infraction in conducting the affairs of the 4th Respondent Association. Despite such finding, having been arrived at the inquiry officer, he has opined that the 4th Respondent